Good evening. I'm glad to be here tonight, and I want to talk. I will talk at some point later in the evening a little bit about the current lawsuits regarding the ban on sharing food with the homeless. But I wanted to talk more generally about criminalization of homelessness. That was only the last of the ordinances that the city passed last year that were part of its criminalization of homelessness. So I want to address that topic more broadly. I think we should talk a little first about the scope of the homeless problem nationally and locally. HUD does an annual homeless assessment report each year, and it's based on what they call a point-in-time count that's done at the end of January each year. And in January 2014, there are about 578,000 homeless people in the United States. Nearly a quarter of whom were children. 63% were homeless individuals, the rest were homeless in families. And those statistics include both people in shelters and people who were entirely unsheltered. In Florida, over 52% of the homeless that were found in that point-in-time count in 2014 were unsheltered, which gave Florida the third highest percentage of unsheltered homeless among all the states. Florida has its own interagency council on homelessness that reports to the governor and to the legislature each year. And their latest report indicated that in 2014, there were over 2,700 homeless in Broward County and 41,000 homeless statewide. And Broward was not counting the largest cities in the United States, the 50 largest cities, but some of the smaller and more regional areas. Broward was one of the top areas within that category for homeless population. And the HUD report also indicated that Florida has the second highest number of chronically homeless among the states, and that is defined as people who have been homeless at least a year or more, or they've experienced at least 4 episodes of homelessness in the past 3 years. Now, I mentioned that these statistics are based on a point-in-time count that's done during the last 10 days of January. There are a lot of factors that diminish the accuracy of those counts, including how many volunteers are available to assist with that count, whether homeless persons are involved in conducting that count because they have a better idea of where other homeless people are than non-homeless volunteers. And ironically, enforcement of criminal ordinances against the homeless actually makes the homeless retreat to areas that are less visible and makes them harder to count. In 2014, there were 16 Florida counties that did not have the resources to even conduct the count. So that in itself has to lend some doubt as to the validity of statistics on the homeless population. Causes of homelessness, the biggest is lack of affordable housing. We've been losing in this country about 10,000 units of federally subsidized housing each year since the 1970s, and there are long waiting lists to obtain that type of housing. And that's per a report of, there's an organization in D.C. called the National Law Center on Homelessness and Poverty, and they just issued a report called No Safe Place, and that talks about the issues. A separate fact sheet produced by the National Law Center indicated that in a 2014 survey conducted by the U.S. Conference of Mayors, The top causes of homelessness for families were lack of affordable housing, unemployment, poverty, and low wages. And for individuals, lack of affordable housing, unemployment, poverty, mental illness and substance abuse, and lack of services to address mental illness and substance abuse. So that's the situation we're dealing with, and unfortunately the way many municipalities have chosen to deal with this, rather than addressing the problems, they've tried to criminalize the homeless. And in that report that I just mentioned from the National Law Center on Homelessness and Poverty, they've been tracking 187 cities since about 2009 and looking at ordinances enacted in these places criminalizing homelessness. And they originally did a report called Criminalizing Crisis back in 2011, and then they've gone back and looked at those same cities in 2014. And so when they first started tracking the cities, there were 34%, and now this is within this group of 187 cities, 34% that were imposing citywide bans on camping in public. 57% were imposing bans on camping in certain public places. 18% were imposing citywide bans on sleeping in public. 27% prohibited sleeping in particular public places such as parks. 24% were imposing citywide bans on begging. 76% were prohibiting begging in particular public places. 33% were prohibiting loitering citywide. 65% were prohibiting loitering in particular places. 53% were prohibiting sitting or lying down in particular public places. 43% were prohibiting sleeping in vehicles, and 9% were prohibiting sharing food with the homeless. And unfortunately, there has been an increase. That was when they started studying this. There has been an increase in these types of laws. And in most of those categories that I just read you, the numbers have gone up. And most notable was citywide bans on camping in public have increased 60%, and bans on sleeping in vehicles have increased 119%. So that brings us to what's happening in Fort Lauderdale. And at the end of the National Law Center's report, they have an extensive number of pages where they have a chart of all the cities that they studied. You can look at each one and see what ordinances they cited as enacted by those cities that basically criminalize the homeless. And one thing I noted in looking at that is that we've probably given the most attention to the ordinances that have been passed most recently. But for Fort Lauderdale, they also noted its loitering and prowling ordinance, its disorderly conduct ordinance. Now those are ones that may sometimes be enforced against other sectors of the population that tend to be disproportionately enforced against homeless people. Fort Lauderdale already had on its books a ban on sleeping in parked vehicles, and also a panhandling and begging ordinance that was enacted in 2012. So the sleeping in vehicles ordinance was actually enacted in 1953 and last amended in 1970. And it's very short, so I'll read you the entire text of it. It shall be unlawful for any person to lodge or sleep in, on, or about any automobile, truck, or similar vehicle parked in any public street, public way, right-of-way, parking lot, or other public property within the limits of the city. And if anybody wants to look that up, that's section 16-80 of the city code. In 2012, the city enacted a panhandling ordinance that defined panhandling and also defined aggressive panhandling. And that was Code Section 16-82. So this prohibited what they called aggressive panhandling anywhere in the city. And it prohibited non-aggressive panhandling at bus stops and transportation facilities, city parks, city parking lots and parking garages, within 15 feet of a sidewalk cafe, within 15 feet of an ATM, within 15 feet of the entrance or exit of a commercial or government building, as well as some other places. So that covers a fairly significant swath of areas in the city. So then we come to the ordinances that were enacted last year. So one of them was a public storage ordinance. The final version passed in September of last year, and that was section 16-83. So if your belongings are more than 20 feet away from you, that would be deemed to be things that you were storing someplace. So let's say you're in a park and you leave your book bag or backpack under a tree and you're 20 feet away, and theoretically you would be storing that. So under this ordinance, generally you would be given 24 hours notice to remove your belongings, but they have an exception if they consider it an immediate threat to your health and safety, like something that has a noxious odor or vermin, or if there's property, or if they've posted the property with a sign that says that things that are abandoned are subject to immediate removal, then they can remove that without 24 hours notice. If they're conducting an area-wide cleanup, they're supposed to provide 36 hours notice, but anything there when they start the cleanup would be removed. And they can dispose of these items 30 days after removal or 7 days after removal if there's a health or safety threat. Now, retrieval requires proof of ownership. I'm not sure, practically speaking, unless the belongings you left behind happen to have your ID card somewhere in there, how people can establish proof of ownership. And payment of storage costs, although if you say you can't pay, then they're not supposed to charge you. Again, I'm not sure what measures the city is taking to determine what is its so-called reasonable storage cost, or who has the inability to pay that. The type of notice that they can give you is personal delivery, delivering to a co-resident at your home, registered certified mail, posting at the location where the items were located, and attaching a notice to the item itself. And the notice has to tell you, among other things, where the items are going to be taken and when the items must be removed and claimed. Now, I've heard at least anecdotal reports that these procedures aren't necessarily being followed. That might be an area for maybe the ACLU or some interested members to do public records requests to the city and find out how they're actually enforcing this. That particular provision doesn't contain a cross-reference to the city's general penalty provision, but the rest of the ordinances that they enacted reference a general penalty provision that leads to either 60 days in jail or a $500 fine or both as potential penalties. So then on top of the ordinance that I already talked about enacted in 2012 that regulated panhandling and aggressive panhandling, designated certain locations where panhandling cannot be done. the city added on to that with a right-of-way solicitation ordinance last fall. And that defined a right-of-way canvasser solicitor as anyone selling, advertising, seeking a donation, or giving or receiving anything by hand, whether or not payment is involved, with anyone in a motor vehicle. So, and that prohibition applies to roadways that are designated on 2 different maps, only one of which they actually included on the website that has the city ordinances. But it was a map called the Broward County Highway Functional Classifications Map. Anything designated as an arterial road on that, or anything categorized as D, E, or F on the Broward Metropolitan Planning 2012 Peak Level of Service Map. So since the ordinance says and, it seems like the roads would have to show up on both of those maps to with the indicated designations to be areas where you couldn't solicit, and that the maps are a little confusing. Even if you take, like, let's say one particular road, like let's say Sunrise Boulevard or something, certain segments of Sunrise Boulevard will be within the designated no panhandling areas, and others will not. So I think it's a practical matter. It would be challenging for people to comply with that. And given the way this is worded, that it encompasses any type of any situation where you're handing something to, let's say, people stopped at a traffic light, it would probably reach a lot of not only people panhandling, but also demonstrators. Often when people have demonstrations, sometimes to better communicate the message, cars are stopped at a light, people may hand them a flyer about the issue they're demonstrating on, so it would reach that as well. So then there was the camping ordinance, also passed last fall, and that pertains to the Downtown Development Authority area. The borders are somewhat irregular, but in some places that's as far north as Sistrunk, and it goes as far south as Southwest 7th Street. The approximate border on the east is US 1, and in some places that's as far west as Southwest 7th Avenue. And so it defines camping as temporarily dwelling with shelter and conducting daily activities such as eating and sleeping. But shelter is defined to include a sleeping bag and a bedroll, so even if you didn't have a tent or a tarp, you would be considered to be sheltering yourself by using a sleeping bag and a bedroll. And then they do look for some indication of other activities, that you have your belongings nearby or evidence you were eating or trying to cook. And citation under that ordinance requires a law enforcement officer to request, and for the person to be cited to refuse a request to leave or to cease their activity of camping. And the officer also has to determine that the person doesn't need medical or human services assistance, or that the person needs such services and is refusing to go to a hospital or shelter. But notably, there's no provision in there for determining whether there are actual shelter beds available for the person, or how the police officer is going to be able to assess the person's need for all these services. The city also revised the ordinance that prohibits urinating or defecating except in a toilet or bathroom, and added a provision pertaining to disposal of urine and feces other than in a receptacle provided for that purpose, out of the view of the public, and disposal must be in a sanitary manner. Meanwhile, there's not really any public bathrooms to speak of in the city, except in, a limited number of public buildings like the public library, but otherwise, they're effectively criminalizing a life-sustaining activity. So that's the full spectrum, aside from the food sharing ordinance. But I mean, one difference between the food sharing ordinance and all the other ordinances is that the food sharing ordinance criminalizes the activity of the person helping the homeless. It doesn't actually criminalize the person who is receiving the food, whereas all the other ordinances that I've talked about go directly to the activities of the homeless themselves. So I'm going to talk about some of the case law that's out there, and some of the also recent decisions and steps by the federal government that Alex alluded to briefly a little earlier. So back in 2000, in a case called Joel versus the City of Orlando, the 11th Circuit Court of Appeal actually upheld an anti-camping ordinance against an Eighth Amendment challenge. But they did that on the basis that there was evidence that was unrefuted that there were more than enough shelter beds available and that nobody had been turned away. So anyone who challenges one of these ordinances needs to basically really get their facts together to show that there are not enough shelter beds for the need that's out there. In a case called Jones versus City of Los Angeles, a Ninth Circuit decision from 2006, the court there held that the Eighth Amendment precluded punishing an act that is an unavoidable part of one's status. So there you had an ordinance that precluded sitting, lying, or sleeping on the public streets and sidewalks. And the court found that unconstitutional, saying, well, these are unavoidable activities for anybody. We're not perpetual motion machines. Everybody has to sit or lie down or sleep at some point. And if you're a homeless person, you have no place to do this other than in public. And in LA, there was substantial evidence that there was a large gap between the number of homeless and the number of available shelter beds. Now, as far as sleeping in a car, just last year, the Ninth Circuit, also again, another case from LA, Desert Train versus City of LA. There was an ordinance prohibited the use of a vehicle as quote-unquote living quarters, overnight, day by day, or otherwise. And the court found that ordinance to be unconstitutionally vague under the 14th Amendment due process clause. In terms of how the officers were actually carrying out and enforcing this, they were citing people who weren't sleeping in their car. They were also citing people who didn't have a lot of belongings in their car that would indicate they might be living in that. So it really wasn't clear what activity it took to trigger a violation. If you were eating in your car, if you were talking on your cell phone in your car, the court concluded the way it was worded, it could apply to anybody, but because it was so vague, they were using that to arbitrarily enforce it against the homeless. Now, stepping back a moment to Fort Lauderdale's ordinance, it did say it shall be unlawful for any person to lodge or sleep in, on, or about any automobile. So, I think it would be, I guess, a prudent or an interesting area for further inquiry if someone wanted to pursue it. Just, whether that term lodge could be considered vague, since they're using lodge and sleep. Obviously, lodge would be superfluous if it didn't mean something beyond just what they meant by sleeping, and and whether that would be subject to attack. Just something to think about. It's not a definitive determination that, but something I think to think about. Now, public storage of property. Again, here we go back to LA. A case called Levon versus City of Los Angeles in 2012. The Ninth Circuit found that by summarily destroying homeless persons' property without any notice or opportunity to be heard violated 14th Amendment procedural due process. Now, there was a case out of St. Petersburg here in Florida, Catrone, where the Middle District of Florida upheld a public storage provision that provided for 36 hours notice before property was seized, that required a sign to be up before items could be seized immediately, and provided that items could be retrieved within 30 days. And they said, yeah, that's adequate procedural due process. That's not a violation. And the 11th Circuit in the same case determined that unlawful storage and unattended are not constitutionally vague terms as they use that in the ordinance. Now, the Fort Lauderdale ordinance is similar, but ours only provides for 24 hours notice. I guess, a court could look at that and we would find out whether they would think the 24 versus 36 hours was a constitutionally significant difference. But again, I think what you probably would want to look at here is what is the city really doing? Are they following their own ordinance, or are they summarily destroying people's belongings without them having any recourse? Now, panhandling. There have been cases that indicate that a blanket ban on panhandling is unconstitutional. That panhandling is a form of First Amendment speech. There are cases that have upheld some of the types of restrictions that Fort Lauderdale put in its 2012 ordinance, such as bus stops, public transportation, that type of thing. But there seems to be more of those in the Fort Lauderdale ordinance than in some of the ordinances that have been upheld. The Homeless Voice challenged in Pembroke Pines an ordinance that was fairly similar to the one that Fort Lauderdale enacted last fall regarding right-of-way solicitation. And they found it was content neutral. And just to back up a second, I mean, basically ordinances are classified as content-based or content neutral, and there's greater First Amendment scrutiny given to an ordinance if it's content-based. And content-based means that either the ordinance is maybe discriminating against a viewpoint or against a whole topic of content. So if somehow an ordinance prevented somebody from, let's say, protesting the war, but allowed somebody to express a pro-war viewpoint, that would be viewpoint discrimination. Content discrimination could be, we're not going to allow anyone to do political speech, but if you want to get up and do an artistic thing, we're going to allow that. So that would be discriminating against different types of content. But if it's content neutral, then although it still may be found unconstitutional under the First Amendment, but it's not as high a threshold. So they found that it was content neutral, that it was narrowly tailored open alternative channels of communication. They found that there were other roads in the city that people could go to do this that weren't included in the Pembroke Pines ordinance. When I first looked at this last year, it seemed to me it affected fewer roadways in Pembroke Pines than the Fort Lauderdale ordinance affected here. Also, Pembroke Pines did an extensive traffic study to sort of document the safety issues with the that were the basis, or at least the purported basis for them enacting this ordinance. There were some documents that Fort Lauderdale put forth as sort of a justification for their ordinance. I'm not sure if it was as extensive a study or not. So moving on to where the federal government is going in terms of homeless issues. So just in August of this year, in a federal case called Bell versus City of Boise, the Department of Justice's Civil Rights Division filed what was called a Statement of Interest. And there's a federal statute that allows the federal government to file statements of interest in different types of pending litigation in which they have an interest. And DOJ pointed out that it had an interest under federal statutes in investigating unconstitutional and abusive police practices, as well as federal statutes relating to programs for the homeless. And the plaintiffs in the Bell case were challenging city ordinances barring camping and sleeping in outdoor public places, and contended that criminalization of this conduct when there was inadequate shelter space violated the Eighth Amendment. And so this statement of interest actually urged the court to adopt the reasoning in the Jones versus City of Los Angeles case I mentioned earlier, which in turn, that case looked at earlier Supreme Court cases from the 60s, Robinson versus California and Powell versus Texas. And those ordinances looked at whether, or those cases looked at whether something amounted to conduct that they were punishing or a status. So in the Robinson case, the court found you couldn't have an ordinance that said it's illegal to be a drug addict, because a drug addict was a status, it wasn't conduct. In the subsequent case of Powell versus Texas, the court was a little more divided. There they were looking at an ordinance that regulated public drunkenness, and the person being prosecuted was a chronic alcoholic. But he had a home and a wife, and there was some argument made that, well, he could have been drunk at home rather than publicly drunk, and so the question was whether that was involuntary behavior or not. And there was some concern about sort of opening up a Pandora's box and allowing people to claim all sorts of things that they were compelled to do and they couldn't control themselves and so forth. However, when the court in Jones looked at these cases, they said, well, whatever you're dealing with on those issues, when you talk about things like sleeping and sitting and so forth, everybody has to do those things. It's an inherent part of being alive and being a human being. So when you're punishing those activities, and having to do those activities in public is intrinsically linked to the status of being homeless, then you are in effect punishing people for being homeless in violation of the Eighth Amendment against cruel and unusual punishment. So the DOJ statement of interest is somewhat comparable to an amicus brief. It's not
I have a question.
Sure.
Once in a while I drive by the bus station in Fort Lauderdale, and in a progressive, mature society we live in, it's shocking how many people are out there that are homeless. On the street you can see them in their bags. Any thoughts and theories why, and I'm glad they're not, based on these draconian laws, why they're not being enforced against a lot of people?
So you're saying you're seeing people congregate near the bus station, and you're saying.
dozens of, hundreds of people. I'm sure
Okay.
if the city wanted to enforce these draconian laws, I would have heard about it. You would have heard about it, it'd be on the news. I hear from the public defender's office, who I have communication with. Any theories on why they're not doing any arrests there? Is it because of the
Specifically
litigation?
at the bus station, I don't know, because as far as I know, the only litigation pertains to the food sharing.
I see.
Moment. So.
So lucky, I guess, basically.
No, that's.
The bus station is redeveloped when the new train comes in as well, so it looks to me, not being linked to any city policy, but it looks to me as a planner, that they're just nice, they're gonna lay low until the whole thing is just like.
Oh, I see. Makes sense. Second and last question. The Utah model, could you comment on that? I know they've built a lot of housing out there, and they basically cure the problem. You know about that?
Well, was that housing first or?
I think so.
Okay. Housing first is a model of providing services to the homeless that basically says first we're going to get people into housing and then we're going to bring them services to deal with whatever other issues they have, finding job placement or substance abuse issues, assistance from a social worker. There were times in the past where cities would say, well, first we'll work on somebody's other issues, and then when they've gotten through those things, then we'll get them into housing. But the housing first model, I think, is proven much more effective. I know it's already being implemented significantly in New York. I think Utah may be another place. So now, my understanding is that the city of Fort Lauderdale, from some Sun Sentinel articles I remember reading a year or two ago, that the city of Fort Lauderdale had funding under Housing First to provide housing to about 22 people. But there's hundreds of homeless, so that's clearly nowhere near the need for that. And you know, something else. I mean, I know in Miami, at various times, the Miami chapter of the ACLU had volunteers enlisted who were actually participating in interviewing the homeless, pursuant to trying to figure out what was going on and how the Pottinger consent decree and settlement was being carried out. The Pottinger case was a landmark case. It was a decision by a federal district judge back in the early 90s where he basically found that the way Miami was policing the homeless violated a number of constitutional rights by criminalizing life-sustaining activities. The decision went up on appeal. The 11th Circuit never actually entered any substantive order, but sent everybody to mediation. And so they reached a consent decree in that case that's been carried out since. The city of Miami did petition for some modifications to that, and some modifications were made last year, but at a certain point they were recruiting volunteers to see how things were being carried out under that consent decree, and it might be worth considering training volunteers to interview homeless in Broward County and see what's happening with enforcement of these. Another thing is that three states have actually passed various versions of the Homeless Bill of Rights. Rhode Island, Illinois, and Connecticut have passed such laws. And now, whether we can get something like that through the Florida legislature might be another story. I think think it's something to look at and think about aspirationally. So I guess to touch briefly on what's going on with the, I think there are actually, by my count, there are actually a total of 5 lawsuits challenging the homeless ban on food sharing. There was one by Reverend Sims who was arrested, I think alongside Arnold Abbott, at the time they first started enforcing the ordinance. There was Arnold Abbott, his attorney reopened the suit that he had many years before, and then also filed a separate suit, I think, in which Reverend Black, who was also arrested with Arnold Abbott, was also a party. Reverend Gail Tapstuff from the Unitarian Church has a lawsuit, and all those lawsuits are in state court. And I think for all of them, part of their claims are under the Religious Freedom Restoration Act. And then the Food Not Bombs lawsuit is in federal court. That was probably the last of the lawsuits to be filed. I have 2 co-counsel on that. Kirsten Clanton is the lead attorney. She's from Southern Legal Counsel in Gainesville, and they have a homeless advocacy project there, and so her practice is substantially dedicated to challenging around the state various ordinances that adversely affect the homeless and homeless providers. And also Andrea Costello, who's from the Legal Services Organization in Central Florida, who worked at Southern Legal Counsel and Center for Constitutional Rights in New York, and is a very seasoned civil rights lawyer. So there are basically 2 counts in the Food Not Bombs lawsuit. One under the First Amendment, based on the idea that sharing food with the homeless, Food Not Bombs, is expressive conduct, expresses their political message that sharing food is a right, and that there's a human right to food, and we should be making sure no one goes hungry, rather than siphoning resources off to war and military matters, and also a 14th Amendment due process claim based on the fact that even though one of the requirements of the ordinance is that you get written consent and written permission from the city, there's no real criteria that spells out how you do that. So those are the two counts in the Food Not Bombs complaint. And basically, I mean, I don't really know what's going on exactly in the state court litigation. We're in the discovery process in the federal suit, and the discovery is the part of any civil litigation where the parties have to exchange information and documents, and depositions of witnesses are taken, and so forth. And so that's where we are. That's about really the extent of what I can comment on that. And so does anybody have any questions?
So is the ACLU in the position of proposing successful policies at either the city level or the county level, whichever one has the power to effectuate the ordinance? And as you have offices all over the country, you know what works in one city, do they communicate that and then approach staff to try to implement it?
I mean, I can't really, I mean, I'm a member of the ACLU. I'm not as organizationally involved in the ACLU, as maybe some other people here are. I'm actually also a member of an organization called the National Lawyers Guild, which is another civil rights organization. And so, I mean, I can't speak to what, I don't know what communications this chapter has had or not had with the city regarding any of these policies. But I think people from the ACLU have gone to meetings where some of these ordinances were proposed and spoke against them, and it didn't seem to. Now maybe, it's hard to say whether if you had a larger turnout of people, if the city wouldn't have enacted these ordinances. It's speculation, but
More grassroots than that. I'm a retired city planner from California, and through my career I've seen a lot of positive ordinances, and I've followed it since then. And I'm just looking right now at the model parking ordinance of Santa Barbara on the coast that allowed registered cars to park on city lots overnight. And I've been just as an individual sending that out to the planning director, hey, consider this because I live by Trivale, look at all that vast open space that's absolutely unused. And so my thought is,
so that could become, so you're suggesting that could become like a safe haven for somebody who is sort of partially homeless, maybe only has their car to.
so I listened to what the deficiencies are in Fort Lauderdale, I'm like, oh, I know some of the policy that we did over here at my work, who needs to propose that to the city? To network the city with saying, hey, this is something that works, you have a problem, it works in this particular city, consider it. Is it the ACLU or is it just,
There's lots of groups.
And I can tell you that when.
Haley Becker's one of the leaders. Haley, what's her name? What's her group again?
Pardon me?
Is Haley Food Not Bomb?
Yeah, Haley Becker is one of the
She was
members
out
of
there
Food
every
Not
day,
Bombs.
this was going on.
And I can tell you that when people spoke at the city commission meetings about these ordinances, people suggested positive. People didn't just say, okay, that this is bad, don't pass it. People did go up there before the commission and suggest alternatives that could provide a solution to some of these issues. For example, I recall reading about in Portland, they established some like sort of porta potty type thing, but I think they called it the Portland Blue, and it was sort of nicer than a porta potty, and it was something they were able to set up to provide a place for the homeless and others to use the facilities in a safe manner.
San Francisco, the Port of San Francisco did a private partnership with a French company to put the ads on the outside of the porta potties, and it was timed. And so at a certain time, the doors would open up because they didn't want people living in the porta potties. It was right on Market Street. And so that's what on the policy. But is there a representative from this organization that can speak to separately aside, if I can just interface with them? Because I have some ideas I want to forward.
Okay, you want to stay for the general membership meeting? Or the director's going to have to do? Any more questions of Mara? I just wanted to recognize Father Bob Caudill, who runs the All Saints Soup Kitchen across the street. I don't know if you want to say anything about
I was coming here to learn something.
the amount of persecution that you've been subjected to by the city of Oakland.
Well, basically, we're in a lawsuit, but it looks like we're going to have to, what's the word, the phrase is retreat to fight another day because 19,000 belongs to a fees or.
Pardon me? 19?
Legal fees, 19,000. So the city, early on, I'm sure knew that they could outlast us with money, so we're going to downsize, move to the church and be there. I'm just afraid after these 20 years we've been doing it, they'll still follow me to the church, but maybe the Federal Protection Act of, what you're mentioning, the church, the religion.
Oh, the Religious Freedom Restoration
Restoration
Act,
Act,
which is
yes.
actually a state statute, yeah.
Yeah, that's what we want to, and you're in Oakland Park right now, Oakland Park has a really bad history, the solicitation, they're trying to pass an ordinance where you can't pass out food on the street. Broward County, if you're homeless, you should move.
Or have a home issue.
If you're homeless. But thank you, you're very informative, I really learned a lot from you tonight.
Thank you.
Well, what's particularly interesting about Father Bob's situation is that in the Fort Lauderdale ordinances, they state they just want the feeding moved indoors where there's sanitation and kitchen facilities. Well, he's got indoors in his own building that he owns with sanitation and kitchen, and they changed the zoning out from under him to say that his previously legal activity is now illegal, and they wanted to cease operations in the building that he owns already.
I guess being illegal is okay sometimes.
But isn't that covered, the actions of a religious organization are covered under the Clinton Act? Oh, the Clinton's Religious Act. That is planning every
Oh,
single.
are you talking about our LUPA, the Religious Land Use and Institutionalized Persons Act?
The way we were told is the city attorney set the planners down at the table and said churches can do anything, everything now because of what Clinton, his mea culpa to the religious community for what he did when he was in office, his exit in passing that. And so that pretty much said, hands off all zoning issues pertaining to churches nationwide. The planners are like, well, what do we do now? We just gotta wait for case law to straighten its way up. So it sounds like, well, that's.
They forgot the law.
I think the Peyote case limited that act, but they amended the statute after the Peyote case. It said because you have freedom to smoke peyote. There's been a lot of changes in that area.
I used to serve on the Homeless Initiative Partnership Advisory Board for Broward County. It's a big title, isn't it? They basically had a $25 million budget, and most of the budget was coming from funding that you were talking about for HUD housing. And but the whole time I was there about 3 years. You know, they provided a lot of services and some housing, but all the housing was for single mothers with children. But you know, that homeless guy standing outside the county library, they didn't have housing for him. And there was always hurdles for the homeless to have to jump through that they weren't capable of, or that they didn't want to do. They would say, okay, here's housing, but you have to do this today, you gotta do that tomorrow, and you need an ID by this date, and they don't wanna do it. And that's why we still have 2,700 people still homeless. But the communications between the county homeless board and the Fort Lauderdale homeless board is almost nil, or at least it was then.
Now, may I ask approximately when this was?
2007 to 2010,
Okay.
or maybe 8 to 11, somewhere in there. Yeah. So it may have gotten better, I don't know, but I don't think they'd be very happy about losing most of their budget. That could hurt the county quite a bit.
I mean, when I mentioned that they've now added that as a criteria, that's certainly not the only criterion that's added to a list of criteria, but whether that would potentially tip the balance between Broward and other competing funds is certainly a possibility. Any other questions?
Yes, a question about what I was asking. Those funds can be used for legal challenges. If you have court fees and you're getting some funding, can you use that for this HUD funding?
No, the HUD funding comes to the cities and the counties to actually provide services to the homeless. It doesn't come to anybody trying to sue the city because they have bad ordinances, so.
All right, Mara, thank you very much for the very informative. I just want to let everyone know that we have a Facebook page for our ACLU.